section 317 of the Penal Code, and the particulars read that Ashok Doshi, Magnum Properties Limited, between 14th day of May 1992 and 2nd day of September 1992 at Alvik House, Nairobi, within the Republic of Kenya, jointly conspired with intent to defraud the government of Kenya a sum of 1.2 million Kenya shillings by fraudulent means, to which forging receipt number C409683 that was meant for stamp duty. Is it true or not true, Mr. Ashok Doshi?
Not guilty and not true.
And as you represent Magnum Properties Limited, is it true or not true?
Not true and not guilty.
Is count number 2 the charge of making a document without authority, contrary to section 357A of the Penal Code, and Mr. Ashok Doshi on the known date, time, and place within the Republic of Kenya, jointly with others not before court, before this honorable court, with intent to defraud, without lawful authority, made a certain stamp duty receipt number C409683, purporting it to be a genuine and be true or not true?
It is not true and not guilty also.
Count number 3, you are charged with forgery, contrary to section 345, as read in section 349 of the Penal Code, and Mr. Ashok Doshi on the unknown date, time, and place within the Republic of Kenya, jointly intend to defraud, forged receipt number C409683, purporting to be a genuine and a valid stamp duty receipt issued and signed the Commissioner of Lands. Is it true or not true?
Not true and not guilty.
Let's count number 4, forcing detainer, country 09/3850 of Greenview Lodge Limited, without color of right, held possession of the said land in a manner likely to cause a breach of peace or reasonable apprehension of a breach of the peace against Greenview Lodge Limited, who is entitled by law to the possession of the said land. Is it true or not true?
The prosecution request.
Let the accused sit down. Okay.
The prosecution makes an application under section 90 of the Criminal Procedure Code, seeking that the court grants our application for service of summons to be issued, to be served upon the second accused person, who is Harit Sheikh. The basis of our application is that said accused person, warrant of arrest, wasn't located at the trace. And therefore we do humbly make that application so that then the investigating officer is able to serve upon the second accused person summons to come and answer to the charges before this court. That is all in regards to that particular application. That is all for that. Then with your kind permission, then you may allow me to address you on the accused persons who have taken plea. It is in regards to bail and bond conditions. Your Honor, the prosecution
Just a moment.
is not opposed. Bail bond being granted. However, we would wish to address this court in regards to the terms and the conditions that the court should set when considering the bail bond terms conditions to be granted. Your Honor, we submit that the bail and bond policy guidelines have set out clear parameters to ownership and right to own property, especially land, is threatened by acts and omissions of individuals who deny the rightful claimants and the owners to have and to enjoy their property without any fear of the same property being taken away from them. Therefore, first principle that is stated is that the nature of the offenses, your legal submissions, that they should be commensurate, the terms should be commensurate to the seriousness of the offenses that the accused persons are facing. The second principle is proportionality of the nature of the offenses that the accused persons are facing. And it is a submission that the four counts that the accused persons are facing, the court should take into consideration that the terms and conditions to be given should be proportionate we have four counts that the accused persons are facing. Including an offense of forcible detainer contrary to section 91 of the Penal Code, in which the accused person is still in possession of that property without color of rights. And therefore it is a submission that
Slowly.
without color of right. And Your Honor, it is a submission that these acts and omissions demonstrates the impunity that is demonstrated by the accused person. And therefore, Your Honor, the court should mete out terms that are proportionate to such kind of acts and omission. Your Honor, thirdly, prosecution is privy and alive to the fact that the accused person was admitted to a cash bail, a police cash bail of 500,000. It is a submission, Your Honor, that the circumstances have now changed. That the accused is now subject before this court, is no longer subject before the police. He is no longer suspect. And therefore, Your Honor, those earlier terms that had been given should not be considered when the court is making a determination what are the bail bond terms that is going to grant. Persons should not interfere with witnesses. Would be lined up to abuse evidence in this particular case. And also to demonstrate the seriousness of the offenses that are before this court. The prosecution also makes an application that the passports of the accused person to be deposited in court. The court makes a determination that the third accused person is also accompanied and Your Honor, it is a submission that bail bond terms should be deposited for each. Your Honor, the law is very clear that a company is
Slowly.
visiting-
Slowly, Mr. Ryung.
Yes.
You are ahead of me. That is Mr. Okwach. Okay.
Submissions.
Usually I write very slowly,
Yes.
comparatively.
Sorry?
I'm not a fast writer.
Okay, no problem.
It's okay.
Your Honor, from the outset, it is our submission that bail and bond has admitted a matter of right. And per section 123(2) of the Criminal Procedure Code. Together with the Kenya Judiciary's Criminal Procedure Bench Book, that
Mm.
underpin two elementary principles. The right to liberty
Take 10 minutes to write my ruling. I'll take about 10 minutes writing. The counsel for the prosecution and the defense counsel. And respectfully, I will not reproduce those submissions in the interest of time. I have also perused the documents availed to the court by the defense counsel in the course of his submissions. There is, in line with the provisions of Article 49, Sub-Article 1H of the Constitution of Kenya, and therefore the question as to whether or not the accused before the court is a flight risk does not really arise at this stage, because the court is not considering whether or not there is any compelling reason. What the court is left to consider is the terms upon which the accused is to be released on bail or bond. The requirement of Section 123 of the Criminal Procedure Code is that such conditions ought to be reasonable, and this is to ensure that the terms are not so harsh as to amount to denial or too lenient to encourage an accused person to abscond. While Article 50, Sub-Article 2A of the Constitution presumes the accused person to be innocent until proven otherwise, excuse me, the nature and seriousness of the charge is an important consideration in determining bail or bond terms. This position is stated in the authorities of Watoro v. Republic, 1982 KLR, and Twaiba, Hashim Mutandi, and three others v. Republic, 2014 EKLR. I am therefore bound to consider the nature and seriousness of the charges while still keeping in mind the presumption of innocence. There is also no dispute that the accused before the court, who is both the first accused and a representative of the third accused company, is an elderly person. The documents availed by the defense counsel show that he is of ill health. The documents availed do not show, however, the frequent need for and use of his passport to travel out of Kenya to seek medical attention in London, because the documents availed bear dates in the years 2015 and 2016. Necessary conditions to ensure compliance with bail and bond terms are not a derogation from the right to liberty or presumption of innocence. With regard to the submission relating to bail, which the accused person may have deposited with the police, I have perused the charge sheet. No copy of the police cash bail receipt is attached to the charge sheet. Neither is any figure of bail posted by the accused with the police, if at all, is indicated on the face of the charge sheet. Nevertheless, both sides are in agreement that the accused person had posted cash bail with the police. Taking all this into consideration, I consider the following terms appropriate. Each of the first and the third accused person is granted cash bail of Kenya shillings 500,000. The first accused, who is natural person, shall have one contact person, and his passport shall be deposited into court as sought. In the event that the cash bail for the third accused is not deposited, the first accused shall bear the natural consequence of non-deposit thereof, and summons to issue requiring attendance of the second accused person before the court to take plea on the next scheduled date, and pre-trial on 2nd of May this year. Orders accordingly.
is a person of ill health as taken by this court, and we were praying if this court, or even in whatever circumstances the court may deem fit, he can be coming periodically the event the court requires his attendance. But because he has no abode in Nairobi, for instance, like today he flew in for purposes of this attendance. He's a person of ill health. Consistent journeys are difficult to bear for him. So we see no prejudice unless he suffered, considering there are already bail terms set by this court. I think it is knowledge well within the investigation.
Move the court appropriately for review with sufficient evidence.
Yes.
Yes.
Most of the
And you serve your colleague in good time.
Yes.
58 of 2015